We are live.
Welcome to Senate Judiciary, Thursday, April 11, 2024. Our first bill this morning, and I think our only bill today, is H655, an act relating to qualifying offenses for sealing criminal history records. And Michelle is going to complete Michelle Childs from Legislative Council, is first going to complete her walkthrough of the bill, reminding us where we were yesterday.
Good morning. So yes, we're picking up H655 is passed by the House, and I'm picking up on page 26. This is section 7607 on the effective sealing, and you'll recall that yesterday we left off in subsection C, which was the list of individuals and entities who would have access to sealed records once they were sealed. So if you look at page 26, I think the last one we had discussed was subdivision 9, which is research entities, and noting that remember the kind of default is that once the record is sealed, those folks who would have access to the sealed records would have access for a period of 10 years. So you take the time of the sentence, plus if it was a misdemeanor, it would be, you have to wait 3 years. If it's a felony, you have to wait 7 years, and then you add 10 to that. So that would be, so like for a misdemeanor, 2 plus 3 plus 10, so they'd have access for 15 years from the date of conviction. If you had a 5-year felony, it would be 5 plus 7 plus 10. But for researchers that are looking at de-identified information, that 10-year limitation would not apply. So the next one we're going to take a look at, in the 10, 11, and 12, you'll see is kind of repetitive language, but this is to allow essentially licensing entities to have access to the sealed records for licensing purposes. And so in subdivision 10, it applies to the Vermont Criminal Justice Council, 11 pertains to OPR, and 12 is for the Board of Medical Practice. So
who's developing the rules?
It would be each entity. So in order for them to be able to access the sealed record, they would be required to adopt rules and go through the LCAR process. If they
should be, is there legislative intent there on these rules?
Well, nothing beyond what you see. Let's say if you look at page 26, on subdivision 10, they have to adopt a process for handling sealed records and maintaining confidentiality, and the standards for determining when information contained in the sealed record can be used for licensing.
Well, I don't understand what, I think it's wide open, and that the intent of the legislature is sealing these the same as expungement, and that no access is granted. That sort of statement in terms of developing the rules that should be done in conjunction with the intent of the bill.
Well, this
sealing of records is done because the person has completed whatever requirements are there. They've completed everything required of their offense. They've gone 3 or 7 years without an additional offense. And we're opening these sealed records for a 10-year period, as I understand it. Just during this 10-year period that these groups want to look at these sealed records. And I don't see any intent here that these records, that we're providing you access for this purpose and only this purpose.
I think that is in there, so it
I don't
says
think
that
it is. I respectfully disagree. I think it's not clear. It says, they'll be kept, sealed records shall remain confidential, not be available for inspection or copying. unless the council relies on such records in a public licensing decision. So that means
Right.
we're going to take that sealed record and make it public for the licensing decision.
It could be, yes.
That's where I trouble.
Okay. Yes, you're correct. And that's just a policy decision for you.
Well, I don't think it should be public at any rate. Why should, because somebody applies to be a pharmacist, why should that be a public record that they were denied that because they had a criminal record? You've automatically opened that up.
I think you want to, you'll learn more from the different entities that are permitted the access, but I think it's not so much that someone has applied for a license, but that someone who is a license holder has been under investigation and they are looking at, either suspending or revoking a license, and that process in itself.
I'm just saying, I don't believe that criminal record should be public.
Okay.
Because it's been sealed.
So I just also want to draw your attention, and the language is the same through these three subdivisions, is just noting that, like, if you look at the top of page 27, is that if they submit their rules, their proposed rules to LCAR, and LCAR objects to either some or all of the rules, then they wouldn't be permitted to be accessing those. So that's kind of, I think we're rethinking language around adoption of rules these days a little bit because of some recent experiences with LCAR objections and administrative agencies moving forward. So the rules would go through LCAR, and they would have the opportunity to object if they felt as though they were not appropriate in terms of maintaining confidentiality. And then in that particular case, they wouldn't have access to the sealed rules. The sealed records.
Interesting. Has to do with hunting coyotes.
So 11 is the same language with regard to OPR, and then 12 with regard to the Board of Medical Practice.
Okay.
Page 28, subsection D, just sets forth the process. So you'll just see it's just kind of some technical language around what happens when the order is issued. And that's in subsection D. Subsection E just maintains, so right now the court is required to keep a special index for sealed records, and they would continue to do that. Page 29, it just strikes subdivision 4 because that's they already have those rules and will continue to do so. Page 30, there's just one small change to 7608 with respect to victims and around the notification issue to victims, just at the addition of the language on lines 14 and 15 that they could try to email the victim at the last known email address.
Yeah, that's interesting. Senator Sheen and I were just talking about much simpler it was before email.
That is true in some ways. So 7609, so you'll recall that when I started the walkthrough, I talked about how the section 1 is just the entire chapter, but there's a few statutory sections that are not amended here. This is one of them. And so this is, you had asked me yesterday about right. And so that maintains, this proposal does not make any changes to the expungement provisions in that section.
Yeah.
There are also no changes for the next few sections on the special fund. You'll recall the unauthorized disclosure. I think y'all did that a couple years ago. Addition of 7611. So moving on to section 2, this is on deferred sentences, and we talked a little bit about that yesterday, and they did change deferred sentence to sealing from expungement, and you registered your...
that you amend that to keep it the way it currently is.
Okay.
For the expungement, upon successful completion.
So that would just be basically leaving the statute as it is
Yeah.
currently.
Leaving the statute as is and not repealing.
Mhm.
They
So-
probably need to, I don't know if you need to put it back in the bill or if you can or whatever.
I think just because I have the whole chapter in there, I would just, leave the statute as it appears. So it would still appear in the bill, no changes. So page 36, section 3. So you might recall this from the legislation that was vetoed. You had this language in there. So a few years ago, the legislature enacted a bill that directs for the expungement of traffic violations after a certain period of time, and you did that, and then that was followed up with something that mirrors that process for municipal violations, and that's what this section is, and this was part of the bill that you had passed, I think 2 years ago, but was part of the bill that was vetoed. So that language is the same. So that would be 2 years following the satisfaction of the judgment, then it would be, the Judicial Bureau would expunge those records. Then moving on to page 38, section 4. So when that new statute on expungement of the traffic violations was enacted, and I only picked this up after Bryn left, so I don't know if that bill came through here or if it was in transportation, but they didn't put in implementation language, and so what's been requested is just that it's clear that that section applies to motor vehicle violations that occurred on or after July 1st, 2021, which is when that went into effect originally. So that's just a little cleanup language. And then section 5 is directing the Chief Superior Judge in consultation with the AG, State's Attorneys, Defender General, Department of Corrections, to submit to the Committees on Judiciary a recommendation on how to establish a mechanism for petitionless sealing. So they use the term petitionless sealing instead of automatic sealing. And any resources required for the recommendation to be implemented. So it would be Judge Zone working with those stakeholders to figure out kind of the logistics and the mechanisms for how that would work, not coming to you with a policy about these are the particular offenses, things like that. That would all be in your court, and as well as whether or not you wanted to adopt anything pursuant to the recommendation.
Is there a particular reason they didn't give this to the Sentencing Commission?
I think they were trying, I don't know. I mean, I think probably just to be a little more focused with it really kind of being a smaller group of people who are the folks who are maintaining those records. And just having Judge Zone be the one that's kind of trying to figure out the technical aspects of how that would all work.
Okay, well, I'm not gonna spend a lot of time on it.
And then also, I think you guys all know, you have from me, I emailed it to you, and then also Ben gave you a hard copy of just a little summary here that might be helpful for you, that just goes section by section, because the bill is rather lengthy and it can hopefully be a little bit of a guide for you when you're hearing from witnesses.
Very good. Thanks, Michelle. We're first going to hear from the Department of Children and Families, and they've provided us with a proposal for H655. And Jennifer Micah is going to lead off, but I think she's going to have Brenda and somebody else with her. Captain.
Correct.
So, good. Oh, you're right behind that.
I am.
I can introduce everybody.
That's okay. Good. Please go ahead.
Good morning, Senator Sears and members of the Senate Judiciary Committee. My name is Jennifer Micah. I'm General Counsel for the Department for Children and Families. I hope you'll bear with me. I'm going to read my statement because I want to make sure I get all the details. This is a complicated and overlapping system that we have in Vermont for our substantiation process and our criminal process. So I want to make sure I don't miss anything. So I hope you'll forgive me for reading, but I think it's the best way to make sure I don't miss anything. With me today is Kathy Clark. She is the director of our Commissioner's Registry Review Unit, which reviews the proposed substantiations that come from the Family Services Division of DCF, and Brenda Gooley, who is the director of operations for our Family Services Division, which is the division within DCF that performs the child abuse and neglect investigations. DCF is looking today to obtain statutory clarification regarding the nature of our records in the context of an order to seal or expunge a record, so that we can be confident that we are accessing records appropriately. DCF often must utilize law enforcement records to fulfill our own statutory obligations. DCF is statutorily obligated to run the Child Protection Registry, and our investigations of child abuse and neglect often must rely on records that are created in joint investigations with law enforcement. In addition, our Child Development Division, the CDD, is the division that regulates child care. They are required by federal law to prohibit certain individuals from working in running a child care facility if those individuals have engaged in certain criminal behaviors, even if the behavior did not lead to placement on the registry. Without ongoing access to our records, we cannot ensure the safety of children. We cannot fulfill the obligations of the statutory mandate to protect children in child care facilities and other areas in public and private life. The Child Protection Registry is a confidential list of names of individuals who have been found after investigation by DCF staff, and after the opportunity to have that substantiation reviewed by a reviewer and go to the Human Service Board. It is a confidential list of names that is kept in a registry within DCF, and it is confidential to the extent prohibited by law, and individuals who are applying for a job in a setting where children are present must provide access, must provide, excuse me, I'm fumbling my words, let me try again. The Child Protection Registry is a confidential list of names of individuals who have been found after investigation by DCF staff, often with law enforcement, to have committed an act of abuse or neglect of a child or children. The limits of the access to that registry are found in statute. Access to the registry is contingent upon specific legal authorization or an authorization by the person seeking a job or a volunteer activity. So if you go and you apply for a job in a child care facility, they will give you a form that says, please authorize us to access the registry to determine if you have been determined to be of risk to children. You don't have to sign it, but you might not be able to get the job if you don't. The report of harm to a child is called into our hotline. There can be up to 4 different and potentially overlapping outcomes. There's the DCF investigation for substantiation. There's a DCF investigation or assessment related to CHINS, a child in need of supervision, which could affect the parental rights of a party. A DCF child care investigation relating to a licensed child care facility, or pertinent to the sealing bill, a criminal case, because we would refer serious allegations to law enforcement. As part of the investigation process, DCF is legally obliged in the most serious cases of abuse of a child or neglect to cede our investigation to law enforcement agency that is also undertaking an investigation of the same incident. Our Child Development Division may also be involved if the harm was at or involves a child care facility. The practical result of this is that DCF does not, in those instances, create most of our investigatory records. We must therefore rely upon the records created by law enforcement, which, once utilized in a criminal case, our criminal records within the definition of Title 13 and the sealing bill. The issue for us then is whether the records that we obtain from law enforcement in these joint investigations are subject to the sealing and expungement provisions of Title 13, even though we use them for our own statutorily obligated processes. We do not believe they are, and we would like this bill to reflect that. An important point to make is that a criminal record can be sealed after dismissal of a case, which could happen within months of a case being charged. An example would be a father who sexually abuses his 12-year-old daughter, and the daughter decides that she cannot or will not testify against him. DCF could nevertheless undertake 3 other actions if the criminal case does not move forward. We could pursue the Chins case. We could seek a substantiation of the father so that if he were seeking work in a child care or a school or similar line of work, potential employers would be aware of the allegation of that he would be unsafe around children. They wouldn't know the specifics of it. They would just know that he was substantiated. The third is to take action against a child care facility. Consequently, if we are required to seal our records.
I didn't do much. Could you hold on?
Yeah.
We need help from the sergeant at arms. If they can't control the crowds, then we should, it's ridiculous that this state house becomes a museum and people come in here. If they were in someplace in Rome, and they wouldn't be yelling like this. This is BS. I'll go out. I don't have my shoes on.
I can talk to this. I got it.
Tell her I want this calm down. This is bullshit. I'm tired of getting broken up in the middle of a meeting. Well, we can't even have a meeting because the people won't control we've got all kinds of people out here, sheriffs sitting here for hours upon hours doing nothing.
I just talked to Agatha. She's gonna talk to them.
Thank you.
Shall I continue?
What's the crowd noise? I mean, somebody evidently thinks they're in this place and I'm just in a bad mood, but
Sounds like they got a handle.
made worse. Thank you.
It seems like it's
Sounds
quieted
it's
down.
calmed down.
Yes, thank you. So we were at the point where we have a criminal case that has been dismissed because of what the victim does want to testify. But we have copies of all of those law enforcement records for our substantiations because we're required to do the investigation with law enforcement. They are obligated to take over the investigation. We are obligated to step back so that you don't have things like having 2 different interviews with a witness, which would be traumatic. So it would completely, if we are required to have our records removed, sealed or expunged, it would denude our records. It would remove everything on these most serious cases from our files and make it, yes.
Comment. My understanding, if I'm remembering right from bills that we did years ago, people have the ability to, lack of a better term, expunge this record that's there. They can apply to either
Yes.
you or the Human Services Board. So these are separate from criminal records. They're not necessarily criminal. They are records of substantiated abuse.
So we have, there's 2 different ways you can do substantiations. You can have the one where we do the investigation ourselves because it is a minor, no child abuse is minor, but let's just say a lesser offense that will not result in a criminal charge. And then there are the more very serious ones where you have serious bodily injury or sexual assault on a child.
Those aren't eligible for expungement.
This is what we want clarified because the statute doesn't make clear that when those records end up in our files, well, they are, if a case is dismissed without a decision on the underlying actions, they are eligible for expungement. They're sealed.
Right.
So that information is still.
If the person's acquitted or.
So for our purposes, like I was describing, a 12-year-old daughter who doesn't want to testify against her father, even though he sexually
Yeah.
assaulted her. So that case might well get dismissed at the criminal court because the prosecutor won't have a witness. But we could still proceed with the substantiation so that the father wouldn't be able to work, say, in a childcare
Right.
facility, right?
Yeah.
But if those records get sealed or expunged,
Okay.
I'm asking, if they're in our files, are they criminal records or are they our records?
You are subject to the sealing. I mean, I guess I'm wondering, why do you think you're not subject to the sealing order?
Because we can't do our work if we are. We can't do this.
That's a separate policy issue from what the bill is.
Well, there are
And so-
other,
Did you raise this from the House?
we did, yes, but it didn't get into the bill. We testified on it, but it didn't.
Did you guys testify earlier? I thought it was like after.
No, we testified before the bill was finalized.
Okay.
Yeah, we did, but the half the committee was there, only half the committee was there.
At the very end, yeah.
Well, go ahead with it.
So,
I think I understand the issue better now. It's the,
yeah,
it's the
so,
it's cases that were dismissed or not prosecuted or where the state lost, but you still substantiated the abuse.
right, and that's a lower level of proof at the substantiation level, so it's a
Senator Buck,
safety
I
net.
think we're all familiar with the child abuse.
Okay, great, we weren't
Through our
sure.
private jobs over the years.
Okay.
Senator Norris was a sheriff and law enforcement, Senator Sheen was a state trooper. Senator Mahowski's a social worker, and I worked
Okay.
at 204, 206,
Yes.
208 Depot for years and had to deal with the child abuse registry, with any, position that opened up.
So I wanted to point out, so something that, Michelle was talking about is why do we think it's different for us? I just had, sorry. This is not a comfortable milieu for
Yeah, I
me,
know.
so I apologize. I'm okay in court, but
Don't
getting
worry
in
about it.
in front of a small group, I'm really
Yeah,
not that
friendly.
great,
No,
so.
I think we all,
forgive me.
what I was trying to reassure you of is that we all understand
Yes,
the child abuse
Thank you,
registry.
yes,
Because we've all experienced interaction with it for one reason or
right,
another.
right,
And, so I think we're all fairly
Okay.
familiar with it, so feel comfortable in describing why
okay,
you need access
Okay.
to what might otherwise be sealed.
thank
In
you.
your example, the 12-year-old daughter who
Right.
didn't want to testify against her dad.
So if a case is dismissed, well, I mean, I think that it's a broad policy question for not just DCF, but all of us around what kind of safety nets do we want for children? This is a lower standard of proof because the liberty interest at stake is a lesser liberty interest than in a criminal case. In a criminal case, they can literally take your body and put it behind bars. In this case, what happens is you may be unable to obtain a job in a place where there are children, where children are really the subject of the work, right? There are jobs where there might be children, like in a motel or hotel, where the employer will not be able to do background checks. But in a childcare center, we are federally and state obligated to do those kind of background checks. We are not parties to the criminal case. We do not get notice of the criminal case. We do not get copies of orders of expungement or sealing. So on one side, we may not ever be told that a case has been sealed. So our records are sitting there in our files and we never know that a case has been sealed. On the flip side, you could have a situation with the father where there's a parallel track of the criminal case and the substantiation case. Our case can get stayed pending the criminal case. If the criminal case gets dismissed for lack of a witness, and then in a period of months, that case could be sealed, and then the former defendant comes to us with the paperwork that says sealed. should we not be able to continue with our substantiation at that point? Because our records are law enforcement records. Or are they our records?
Can I offer something under
Yeah.
So I think we understand the kind of tough spot that you guys are in, but if you look at like the definition of criminal history record, which is taken from Title 20, which
Yeah.
applies through for the expungement and sealing, I can see how there's like a mismatch with some of your records as well, right? And so I think probably what would be helpful, and I don't know if you've done this in what you brought today or whatever, is to be able to identify for them what is yours, separate and apart from like the definition of criminal history records with regard to the individual's contacts with law enforcement, arrests, things like that. And if we can kind of separate those out, and then thinking about in terms of whether or not, you know, how they want to approach the access for y'all to the other information, whether or not it's valuable to you with the criminal history record, if it's separate apart from your information, because I'm assuming that it's all mixed up, right? It's not all like, here's our records over here. You're gonna have, if there was, let's say if a law enforcement officer did the questioning of a child and the DCF worker was there, like it's all gonna be mixed up in your records, right? It's not gonna be segregated.
Yes, but I think what I really need to make clear is that law enforcement is doing the investigation and we're getting copies of their records. We're really not creating very much when there is a joint investigation because we are legally required not to do that.
So can it just be that you guys are looking for access to the sealed record for a period of time, or you're looking for always having access for ever?
Right, so there's a couple things, and we can have Kathy talk about that a little bit, but we need access for the initial substantiation, but then later, when somebody comes in to have that record expunged from our, confusing because it's the same word, but they can come in after a period of time that's under regulation. They can come in and ask to have that record expunged from the registry so that their name will no longer be on the registry. And in order to do that, it could be many years later that they come forward. So we need to be able to see those records, to see what happened, and to see what changes they've made in their life to make them safer around children. So if we lose access to the records, we will be ignorant at the time at which the person comes back to us and says, I want an expungement. They will not be ignorant, but we will.
I understand the problem. I don't know how to write it.
So would you just be looking, sorry.
We have two proposals. One would be to exempt DCF records from the definition of criminal history record. So that we would say a criminal history record does not include records obtained by the Department for Children and Families in the course of joint investigations with law enforcement pursuant to Title 33, Chapter 49. So I'm being very specific here. I'm not looking for an overly broad exemption. It's just when we're doing our joint investigations. The other option would be to make a change at 7607 subsection C, so that it would say information and materials gathered by DCF in the course of a joint investigation with law enforcement, including law enforcement affidavits and related references to information, are considered department records that may be relied on by the department and shall be maintained as statutorily prescribed. And then I cite the particular statute.
So now, Michelle, would you want to ask your questions?
I have that, and I can provide you with, that language is in the PowerPoint we gave you,
Yeah,
but.
but we've got that in front of us.
Yeah.
No, I think, those are just two positives that you guys could choose between those. Or I guess one question I would have is whether or not, this would apply, I guess if you had option one, then that's kind of a blanket and
Right.
it takes them out of that definition. I'm thinking about kind of the distinction between, the circumstances where you said, okay, there was a, case was dismissed,
Right.
or whatever it was, but that there was something that, might be like a cruelty to a child charge, or a sex offense, something that would not otherwise be eligible to be sealed.
Right.
And so would you be looking for it for those types in like those subset, or you'd be also looking at, I guess maybe it just wouldn't have any applicability, but I'm thinking about like the eligible offenses that are under that refer qualifying offense, which don't, maybe they have some relevance to your, if there was maybe a felony drug sale or something, I don't know if that would have any relevance for you. I'm trying to think about the scope of the types of offenses, because you're probably looking for certain things.
We're not looking for offenses that we're not involved in. So the drug offenses are likely not to be something, unless somebody was giving drugs to a child or something like that, like those, which would also have other charges connected with it, I would think.
Well, you do have a criminal history record, though.
We can obtain that.
Yeah,
We
you
get it,
can
we can get it through
get-
BCIC like
For
anybody
example,
else, but
you know the criminal record of the individual.
we do, but
You don't, somebody behind you is shaking their head.
we know some of it, we know some of it.
Yes, sorry, Senator Steers, I'm trying to.
Yeah, I
my hands
understand,
here. Right,
you're
we
in
know-
a position where your head was just behind.
Sorry. So I'm Catherine Clark, so I'm the director of the Registry Review Unit. I don't wanna.
Would you like Kathy to come up and talk about
Well,
that?
I
You
just,
just sit
I
right here,
think,
then I'm not
I think
distracted behind your head.
understand, that's much better. I can see all three of you now. I'm just, I thought that you have access to the criminal record of somebody applying to be, for example, a counselor at a group home, that you would have access to that record.
First,
And that record would be part of your decision whether or not they're on it. But this is just the child abuse registry, correct?
right, it's the child
So
protection, yeah,
robbing a bank wouldn't get you on the
Right.
child abuse registry.
correct.
Okay. Might get you other things,
It probably will.
but, okay, so I'm clearer now. This only, so the records that you might have and would want to protect are ones where there was an investigation for child abuse, child sexual abuse, neglect, et cetera.
And where you substantiated those records, even if there wasn't a parallel criminal
And
charge.
could you remind us of the process that somebody goes through to get off of the, currently, to get off the registry?
Would you like to talk about that, Kathy?
Sure. If I can try to share, although I'm getting a little warning that my bandwidth is low, so do you want to just look at what we've
Well,
already
just
provided?
briefly, that
Reference?
people have the right to, what I'm trying to establish is that even though we would be if we were to provide either option one or two, you still, as the individual who's on the registry, has the ability to get off of the registry.
That's right.
That's what I'm trying to establish.
That's right. There are two ways, and thank you for asking this question. There are two ways that an individual can try to get their name off the registry. The first is to request a review, which is after they've been substantiated, they can contest the finding itself. So they come in, they meet with an independent reviewer with the Commissioner's Registry Review Unit, and that at that point, the reviewer hears from the individual, they review DCF's record, and they make a decision as to whether that substantiation should be upheld or overturned or sent back to reopen. And that standard is if a reasonable person would believe that the report was based on accurate and reliable information that would indicate this child was mistreated by this individual. So that's the standard. That decision, if it's upheld, can be appealed to the Human Services Court, where there is a de novo hearing, it's a full evidentiary hearing. If the HSB affirms the substantiation, that individual can then appeal to the Supreme Court. Those are the avenues for contesting just the substantiation decision itself. And irrespective of whether an individual chooses to contest the substantiation or not, After their name has been in the registry for a period of years, they can petition for the expungement of their registry records with the commissioner. And right now we have 4 tier levels, 1, 3, 7, and 15 years. But after they've reached that period of time, they can come back, present information, where, for instance, their criminal record would be reviewed. And the commissioner then would then determine if they continue to present a risk to the safety or well-being of children.
And there is an appeal beyond the commissioner.
That's correct. They can also appeal.
They don't like the
to Human
commissioner's
Services
decision, they can go to the human service.
That's correct.
Yeah.
That's correct. And so the way that this bill, or the way it potentially impacts our work is first, I'm sorry, did you have a question?
Yeah, I just had a question about the tiers. Is
Yeah.
that based on what type of abuse, or is that at 1 year, is that 3 years, at 7 years, and at 15 years are the points in time which the person can come before?
It is based on the future risk to children. And it takes into account what's in the statute, which it takes into account the nature of the abuse and other factors, yes.
Okay, thank you.
Uh-huh. So I'm sorry, the way it impacts our work is either at the review stage, as Jennifer mentions, an individual, we see it for these types of sex abuse cases. We also see it in domestic assault cases where a child's been around the incident that with the perpetrator when they acted in this criminally charged, and they get substantiated then for placing this child at risk of significant harm for injury for the child, and then the criminal case falls apart. The caretaking parent isn't willing to testify, and those are getting dismissed or pled down to civil assault, which is then making it eligible, and they're coming into the review meeting saying this has been expunged or sealed. So that's the first place, and then the second place is with the expungement. So when we come back after a period of years, it's no longer there. And if we then look at the judicial portal, we don't see it. So if we didn't know the record they would ever charge, we wouldn't know.
I mean, if the record got expunged and you wouldn't have access to it anyway. So if it was 20 years after the fact, you wouldn't have access to it. So you're talking about your joint investigation. It's not that you, all of a sudden, Mr. Sears has applied for a job at Depot Street and they're doing a records check, and I had a record that's 25 years old that was expunged. You wouldn't get access to that. You're talking about something that you investigated, alleged child abuse or neglect or whatever. That what you did jointly with the law enforcement, you don't want your records expunged. So I don't know which is better option, one or two, but I personally, as one member of the committee, don't have a problem with providing that understanding, because I understand they have the opportunity to get off, and that was done. Oh my gosh. Jim Letty was on this committee and chair of health and welfare years ago. And the health and welfare used to meet in the afternoon. So he and I worked on this issue years ago to establish what was the ability to get off. We had both had experience where we thought people should have the ability to get off of the registry. So it's kind of expunging.
Yeah, given that there is a process for someone to show the work that they've done and get off the registry, and that we're dealing with different records that belong to DCF and not to the courts, I feel okay allowing them to retain access to their records. Especially just, it's a different pathway and a different process. So that feels okay to me.
Which one is option that's the best for you?
I like the first one the best, because I think it makes it very clear for anybody, well, because that's what we're talking about. We're like, is this a criminal history record or not? Because it's such a broad category, that definition is very, very broad, but we don't actually, like I said, we're not involved in the criminal case. So we're not notified. And as Michelle testified, they're talking about creating a committee to determine the operationalization of automatic sealing But we are not part of that, because nobody's thinking about us in the context of the fact that,
Would you,
of criminal records. And even Michelle used the terminology, the people who are involved in the underlying case, and we were not.
I don't wanna overstep here, but
Yeah.
I think we should hear from the Department of Aging and Disabilities, because they have I think they're the ones with the adult abuse registry.
They are, and I understood they did want to be heard on this.
So I would think whatever we do for them, it should be similar to DCF. Because they're two different registries, but they both deal with the same issue,
Right.
being able to work with vulnerable populations.
Right. I think it's a little bit, for us, we have so many cases,
Yeah.
so it's a much bigger workload for our department, so we're just much more
Yeah,
aware
but
of it all
I
the
think it would
time,
be a
and they have
mistake
many
for us
fewer.
to give you access and they wouldn't have access.
No, it would be an inconsistency. It wouldn't be
Yeah.
as important for them because they only have, I don't know, a couple dozen a year. So
Right,
it's
but
not-
it's
It would
the
be an
same.
inconsistency,
Yeah,
right? Yeah.
you would end up with somebody who would work with a vulnerable population.
Right.
Senator Sheen.
Thank you. Yeah, I'm good with this, and I was also flipping back and forth between option one and option two, and it does feel like option one is a little less specific, which in this circumstance, I feel like is a bit easier to work with, for you. And so I can see how option one is, makes a bit more sense, and so I'd be supportive of that.
Did you contact the Office of Aging and Disabilities to assure the general counsel? And
Bring me in next week.
yeah, bring him in that, but also provide him with a copy of BCS. Tell him, you know, tell them that they could talk to BCF if they wanted to.
And then we'll propose,
I
we'll
think they're
provide.
the same agency.
We are the same agency, still, I don't know how much longer, but we'll see.
So if they, you know, he could come in if there's something on here, you know, I'd like to make sure we have both registries. Recognizing that there's as much knowledge.
Not to discount the importance of it, just that it's not as
Yeah.
high on their radar as it is on ours.
Well, they may not be aware, and if we didn't include them, then that would be a mistake.
Is there anything else he's looking to say?
Can I just ask one question, just a clarifying question, and I can meet with y'all afterwards, just to make sure, I just wanna make sure that
Sure.
we're putting it in the right place and that we're covering all the bases in there. We're going with number one is, so, would you wanna, so like, if there is a police report in your files, you would wanna be able to maintain that police report. Okay, I'm just trying to think about get it, because, you know, you're not a criminal justice agency, right? And then the criminal, I'm just trying to think about how to parse it all so that you can actually keep what is a criminal history record in your records and
Right.
exempt you out of there. And I just want to make sure that we've got it covered. So I'll think about it and
Yeah,
maybe
and
play
we
around with
do-
some language, and then I'll circle back with
Right.
all.
And we do, segregate the record, like if we know something's been sealed, we put a big bright piece of paper on it and stick it in an envelope, and so we do know when things have been sealed. Well, when we know, we can do it. If we don't know, we can't do it. But yes, because if the law enforcement were the ones that did the interviews, then that's the only way we get the information, so, yeah.
How do you deal with juveniles who are currently in your, or were in your custody, who committed some of those acts? How do you deal with them now? Because those records are supposedly
Those
sealed.
records, those are sealed. We do
So
not.
how do you
we-
deal
we-
with
we
Joe
seek orders.
Jones, who was in your custody, who abused a child or whatever? And now you have, he's on your registry, I assume.
Yes,
So how do you deal with that sealed record?
we file a motion with the court and ask for it to be
You have to
sealed.
file a motion
We
with
have
the
to
court
file
to
a
open
motion.
that.
And depending on.
You open your own record, you have to file.
Yes. Yes. That's our process now, because,
But he would appear on your registry if he applied for a job.
yes.
Yes. Children do end up on the registry sometimes.
Okay. Well, that's helpful to know. Because you're dealing already with sealed records.
And well, only on motion by the court, only on granting, we have to ask the court for that, is what we're currently doing with the juveniles. And it is so helpful though, because as you know, there's great treatment records in that, right? And we can then get that information when we're discussing or deciding whether to expunge a record. And we can say, yeah, you've done everything you did, these are the programs you engaged at up in Depot Street, and it shows this change in circumstances to grant an expungement.
I remember hiring somebody who was on your registry, who had been in your custody, but also had a criminal record. And the agency said no, but everything occurred before he came to the program. This was like 10 years later. And I can't remember who I talked to at DCF. This is in probably 20, early 2000s. But, eventually he did get hired. It's a good story because of his relationship with the kids. And that particular program. But his were not sexual abuse.
I think we're more attuned now too, right, to the idea that people do grow and learn and change, and that's something that we would.
All right, well,
value
thank
the
you.
record.
Yes, Senator Norris.
Yes, I just have a quick question, and I was wondering, probably has no bearing on this, either you or Michelle. Is there protections in place or guardrails, whatever else, to those records that DCF possesses that they didn't obtain through law enforcement? Are they susceptible to FOIA and or subpoena requests?
No.
No.
Well, subpoenas, depending on the subpoena and depending on, if there's a subpoena, we usually oppose it and then it goes to court and the court decides. But our records are not available to anybody except in certain limited statutorily prescribed circumstances.
Thank you.
Thank you.
All right, thank you very much, and thank you for your patience.
Yeah.
Appreciate it.
All right. And representing the Attorney General's office, next is Rose Kennedy, who many of you may remember is the state's attorney in Brooklyn County.
Good morning, Chairman.
Good
morning, Senators. Thank you for having me. So
Nice to see you back.
well, it's nice to be here. Thanks for squeezing me in. We appreciate it. My name is Rose Kennedy, Assistant Attorney General, testifying on behalf of Attorney General Clark. Let me start by saying that the Attorney General strongly supports this proposed legislation and appreciates this committee's work on it. The AG believes this legislation is a very important data-driven criminal record clearing bill that will benefit many Vermonters who, having been convicted and having completed their required sentences and having paid their restitution, deserve an opportunity to move past their convictions and explore educational opportunities, advancements in employment, secure housing, and become overall more engaged as community members generally. The AG firmly believes that allowing these folks who have already been held accountable for their criminal conduct the ability to move forward will ultimately benefit all Vermonters by creating a more robust workforce, a better trained and educated population, and a reduced number of folks in insecure housing situations. The benefit of H655 is that it greatly expands the type of criminal records that can be cleared, streamlines the process, shifts the burden onto the prosecution to demonstrate why a sealing is not warranted, and moves towards automated sealing, which are all important factors in improving access to justice and creating efficiencies in the system. The AGO supports the different timelines that have been outlined in the bill before sealing can take place, namely the 3 years for misdemeanors, the 7 years for felonies, and the 10 years for DUIs. We would just note that 23 VSA 1210 allows the state to prosecute a DUI 2 if a DUI 1 occurs within 20 years, so that language seems consistent with the statute. Additionally, the AG supports the changes that have been made in section 7607, beginning on page 23, We believe that this language reflects the important reasons why a person's criminal record history, while unavailable to the public, may still be necessary for legitimate purposes, including for law enforcement and public safety. The AG believes that the current language reflects a reasonable balance in these competing interests and emphasizes that the goals of increased housing, employment, and educational and training opportunities are not impacted by this section. Again, the AG's priority is to clear these criminal record histories from being public-facing. As you know, the Attorney General's office often defends the state when sued. So in wearing our civil litigation hat, we would like to propose language in section 7607C1, which is on your page 25. And I can provide
Let's
this.
get there.
Okay, yeah, I can also provide this in an email to make it
That
easier.
would probably be helpful for us and Michelle particularly, but
It's not a big
on
change.
page 25,
On page 25, that's subsection 1.
yep,
We would just, we reworked it to say an entity or person may continue to use a sealed record for any litigation or claim arising out of the same incident or occurrence. I think there was concern about whether we possess it or whether we have to obtain it in order to defend civil litigation. So we believe that that slight change makes it a little bit clearer that we can obtain it.
I'm sorry, can you see what that changes again?
Yeah,
I'm
of
so sorry, I
course.
missed it.
Yeah, I'm
Well, she's gonna
sorry.
email it anyway.
Okay.
Yeah, I will. I'm sorry, we were talking about it late yesterday, so. I also want to note.
Could you repeat it though?
Do you want it now? Sure.
Yeah.
Any entity or person may continue to use a sealed record for any litigation or claim arising out of the same incident or occurrence.
Great.
I also want to note number 6, which I think is on page 26. That provision discusses the discovery obligations of prosecutors. I would just ask this committee to keep in mind that under the rules of evidence 609, an impeachable offense can be for up to 15 years. So let's say a misdemeanor gets sealed after 3 years, and then I'll use the term super sealed after 10 years, and then that is no longer available to the prosecution. Potentially a new defendant would have 2 more years to use that conviction for impeachment purposes. And so just asking this committee to keep that in mind, that it's not really clear what happens in that situation. We understand that this committee may hear testimony, and again, I use the term super sealing. That's the provision at the end of section C on page 25 that limits the use of sealed records even to law enforcement or the Attorney General or others to 10 years. The AG recognizes that this is, again, important compromise language and so supports it generally. However, the AGO also appreciates that navigating this issue between sealing and destroying a criminal record may require further conversation, and will happily participate in those discussions to assist in passing this legislation into law. Finally, as you know, I was here yesterday and was able to hear some of your comments and concerns. I was able to discuss those with Attorney General Clark. We would be in agreement with putting the language back about expunging deferred sentences. We also agree that if something was a conviction, but that behavior is no longer criminal conduct, that should be expunged. So again, we understand that there will be more conversation about some sort of cutouts for expungement, and we want to be part of that. So far, that is all I have for prepared statements. I'm happy to answer any questions, but we may be asking to come back as, you know, if the conversation changes.
This is a complex bill, one that's built on compromise and trying to get everybody's interests aligned, but I do appreciate the position of the AGO. And I hope that we can get it right. And then there was one question I had, maybe for you or Michelle. last year in the miscellaneous bill, we took care of careless and negligent driving because many DUIs are pled down and yet we didn't allow careless and negligent to be expunged. Is that still sealed or expunged?
It's whatever it would be under current, what you have under current law,
I
because
think
it's
it would be a
not,
misdemeanor.
is it a misdemeanor?
Yeah, so
I don't know,
it-
I didn't do miscellaneous law.
Yeah, no.
So it would be a default misdemeanor?
You know, I haven't
Can we just check
memorized
on
all
that
these
because it was,
exceptions, but I assume it would.
it got to be, for defense attorneys particularly, they would get their client, a deal with the state's attorney in low BAC levels to go down to careless and negligent and instead of DUI, but they couldn't, but even though you could get a DUI expunged.
After a certain amount of time?
Yeah, you couldn't get a
So you
CNN,
want, so you
we
want
want,
a CNN?
we want whatever was in last year's miscellaneous bill, I think Eric did it.
But did, what was in the miscellaneous bill, did it address expungement or stealing specifically?
Yes,
Okay.
Just
all
looking
right.
at your exceptions, I think would be classified
I
as a
just wanna make
misdemeanor.
sure it's still there.
And be sealed
so we
after
don't
3
have
years.
that disparity.
Mm-hmm.
No other questions? Okay, thank you. Thanks, Scott.
Yeah, I had somebody who could have gotten their DUI expunged if it was a DUI. It's like 20 years later.
But because it was
They
a
couldn't-
careless and negligent, they
Because
could
they're
not.
careless and negligent, they couldn't get it expunged.
Yes, that is certainly an inconsistency.
And so he should have stuck with it.
Well.
Shouldn't have. He got it, but he was very happy at the time, and, you know, all this changed. Anyhow, so our next witness is not until,
Tucker Jones is on there.
who?
Tucker Jones from,
Not Jay Person Johnson.
It's on the other side.
That's after our break.
Okay, so we get back at 10:30?
Oh, no, on the other side, Tucker is, he's on Zoom right now.
Oh, he's on Zoom right now? Okay, well, we're gonna take a break at 10:15. But I thought we had, oh, Tucker's, okay, I'm looking at the wrong. I missed Tucker, I'm sorry, Tucker. I jumped right over you, didn't have my glasses on.
You
It was
you
not
don't
on
have to
purpose.
apologize, Senator Sears. It's all right.
Okay.
Senator, I'm flexible. If it's better to come back another day, I know you have a long list today.
No, that's, how long is your testimony?
I can try to, it's 10:05 now. I think we could do it within 10 minutes.
That sounds fine, let's try.
Okay, yeah, no, it's fine. Well, good morning, everyone. My name's Tucker Jones with the Department of Public Safety. Happy April. Thanks for picking up this bill. I wanted to just start with an observation from this morning regarding the operational challenges that Attorney Micah was discussing at DCF. And those challenges aren't unique to DCF. The breadth of this definition of criminal history records has had some ripple effects to underlying records that I don't think had been fully thought out, of course, with this original sealing and expungement scheme. So the effort to simplify this scheme and shift towards a sealing only scheme is generally supported by many of these government entities that have to interact with these records and determine what they should be doing with them. One of the key points that Attorney Micah was raising is this idea of dismissed cases under Section 7603. And, you know, the dismissed cases are eligible for sealing regardless of whether it is a qualifying offense. And dismissed cases occur routinely in criminal court where prosecutors are dismissing cases not necessarily because there's been any determination that the underlying events didn't occur, but they're dismissed because of witness availability, They're dismissed as part of plea agreements where people are pleading to other offenses. And so the result is under 7603, now there are provisions for sealing, and currently there's a provision for expungement 8 years later for dismissed offenses, regardless of whether it's an eligible offense or not. And that has been problematic because it has, as Attorney Micah was pointing out, that has brought into the fold sex offenses, other victim crimes that weren't really contemplated under the eligible offenses under current law or even under this proposal. So addressing some of that is important, but the Department of Public Safety has its own operational hurdles with sealing and expungement. And I'm kind of introducing the topic today, but you may, at the end of it, may want to have the director of the Crime Information Center, Jeff Whalen, in to discuss more of the details of what I am flagging. So just for context, in 2018, VCIC processed 2,500 sealing and expungement orders. In 2023, they processed 22,000. So this is a pretty substantial operational process for VCIC, and they want to make sure that they can accommodate the changes that you're contemplating here. But we do have one major operational challenge that we're trying to work through. And that is on March 15th, the day of crossover, House Judiciary added this provision limiting entity access and use to sealed records after 10 years, right? And you've been discussing that. That's on page 25, lines 1-2. Some have described this kind of colloquially as super sealing. I did speak with Jeff Whalen, the director of VCIC, after this was passed on March 15th, and he did describe this as being problematic for him operationally. And as I noted, he can come in to discuss this with you in more detail. But in short, the current record management system that they use for records of arrests and prosecutions doesn't have the ability to add a date tag when a record is sealed, and it does not have the ability to filter records in such a way that they are preserved but inaccessible to criminal justice agencies. This is an IT topic. It's a kind of a record management topic for him, but this proposal here contemplates that government entities listed there, and specifically criminal justice agencies, would not be able to access or use a criminal history record after, 10 years after it is sealed. And so a major question operationally is how that would be achieved, because we don't currently have the IT system to limit law enforcement or criminal justice agency access generally. We're open to working that through with the committee and working it through operationally, but it may be worth hearing directly from Director Whalen as
But
to.
he's scheduled next week.
Great.
We're going to schedule next week. I don't know if he's heard yet, but
no,
that
I'm glad, because he can speak more directly to what those operational challenges are. It does, the proposal though of 10 years does, I believe, also raise some policy questions separate from the operational issues at VCIC. The most basic one is, does this proposal really simplify the current system? We would now be having sealing, we would be having super sealing, and we would also be preserving expungement under certain circumstances. And then, I haven't been involved with it, but H645 preserves some other provisions for the deletion of records in the pretrial diversion context. So I am just flagging that we may be exiting this session with 4 different forms of limiting access to criminal history records that might be operationally, while it is operationally problematic already for VCIC. But the other bigger policy question is whether limiting access and use after 10 years is going to have some unintended consequences, given how broad the definition of criminal history records are. So we read the broad definition of criminal history records, for example, to include people's fingerprint records, and other records that are the underlying records that are not just the records that contribute to someone's record of arrest and prosecutions, their rap sheet. And these underlying records do have some utility in law enforcement investigations beyond 10 years. There's basically 2 areas where old records are still potentially relevant. And one is the identification of suspects in the future based on old fingerprint records. And the other is old cold case investigations and the ability to review incident narratives from the past to try to find new connections from an event that occurred a long time ago. And so this is a policy question of whether it is a good idea to be limiting access and use for those types of investigative purposes. So that is one bucket that we have kind of an ongoing potential concern here, that we are open to working with folks, working with this committee and working with the other stakeholders to iron out. And it's primarily an operational hurdle, but it also has some policy consequences that we want to make sure are taken into account and considered. The other operational hurdle that I flagged for House Judiciary, and I really just wanted to flag it for you, is that entities that are not criminal justice agencies cannot obtain sealed criminal history information from VCIC, from the Crime Information Center. Director Whalen doesn't have the ability to grant access to sealed information to entities that aren't criminal justice agencies. So they would have to obtain that information from another source, most likely the courts. And there was a provision in one of the House versions that that clarified this, or specifically indicated that entities would be obtaining these records from the special index. I believe that was removed at one point. And I just wanted to kind of raise the topic with the committee, because this bill contemplates that some non-criminal justice agencies would have access to sealed information, and Director Whalen doesn't have the ability to do that. So those are the 2 operational buckets that we are working through now. And as I said, we're open to working this through with the committee. Our hope is to move away from expungement, move towards a simplified system, and that preserves, appropriate access, and recognizing that the amount of time, 10 years, whatever the time is, we're trying to think through whether that is the best way to contemplate limiting government entity access, or perhaps another approach is to adjust the definition of criminal history records so it doesn't necessarily encompass as many records as is contemplated under current law.
So just so I'm clear, and then Senator Bowski has a question, Tucker. When you say non-criminal history records, such as fingerprints, DNA, I'm assuming, things like that, are non-criminal records? In other words, if you had the fingerprints in your database, which somebody applies for a job, their fingerprints are there, they wouldn't know there's a sealed record. But the fingerprints are still there in your criminal justice database. The DNA is there. If you had a cold case and you were looking for a DNA match for something that was 20 years old, that DNA would still be there. Otherwise, is that the non-criminal justice record we're talking about?
Yes, so we would consider that a criminal history record. The current definition is all information documenting an individual's contact with the criminal justice system, including data regarding identification.
Well, okay, so you would like an exemption for the data regarding identification?
That's part of it. That's part of it. Another bucket of information that's currently considered a criminal history record are the underlying incident narratives, affidavits, and other information contained.
That's very. Okay, so if you could propose in writing what you'd like to see.
I'll do that.
Yeah, because you got two buckets. One bucket I understand and I tend to agree with. The other bucket, I'm not sure. So you could put it in writing there.
Will do. Thank you. I'm sorry, I took more time.
That's okay. Senator Wachowski.
It's all right.
Okay, thank you, Tucker, and look forward to seeing you next week.
Thank
Maybe
you.
we can continue this conversation with Jeffrey Walling at the same, have you and Jeffrey at the same time.
We'd like that. Thank you.
Okay, so we're gonna take a break until 10:35.